Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to talk about the inevitable moment when you get diagnosed. Gosh, that doesn't feel good, does it?
No, it feels icky.
And it comes with a lot of anxiety and a lot of concerns in a lot of different realms.
Right.
But the one that we're going to focus on is something that you can control. Because I think when I hear about clients and even in my own family when people have been diagnosed, there's been a lot of feeling just totally out of control. What happens next? We don't have the right information. We don't know what the plan is. We don't know what the outcomes are going to be. And so amidst all of that uncertainty, I think that we can deliver some certainty in that environment. And I think that's what is really wonderful about being able to turn to this question of, all right, so yes, I've been diagnosed. I guess I do have an expiration date. I don't want to think about that too much, but at the same time, there is a real obligation to be able to implement some legal steps that will help your family, your loved ones, and maybe most importantly, yourself in regaining a sense of control. And so, Matt, why don't you tell us what one of the important elements is to put into place right away?
Sure. And before I do that, Kirsten, I just want to mention that, when you're diagnosed with some sort of condition and you know that, like when you mentioned, that expiration date is coming maybe a little bit sooner than you initially expected. One thing that's really interesting is that your care team puts a plan in place. Here's how we're going to provide care for you. Here's your treatment options. This is a great time for you to also put an estate plan in place. And if you have one in place, take a look at it. Make sure that it checks all those boxes that you need. But if it doesn't, then here's our recommendation. So first thing that you have to have in place, in our opinion, hands down, powers of attorney for healthcare, powers of attorney for finances. Almost sounds like a no-brainer. The reason that I want to bring that up is because if you're diagnosed with something especially very serious, the chances of you having a form of incapacity, those just went up significantly, right, Kirsten?
Yes. And I would say that power of attorney for finances and healthcare have been around for a long, long time, but there have been substantial updates and revisions and even changes in terms of your approach to these documents over the course of the last several years. So just because you might have a power of attorney for healthcare or finances does not necessarily mean that those documents are correctly drafted, that they are updated with respect to the law, and that they address all of the important elements. So for example, the important elements of the power of attorney for healthcare include addressing under what conditions do you want to receive or not receive certain types of healthcare? What about if you are going to be intubated or having a feeding tube? What is your feeling on that? And how do you want those feelings and desires reflected in the document? What about guardianship? What if a guardianship is needed for some reason? Do you want the same people in your healthcare power of attorney to also be your guardians of the person? And then there's the issue of exonerating the people that are going to be making decisions on your behalf. Also, it is very important to decide who you want to be making decisions on your behalf. Very often we get people in here who are saying, I put my sisters in place a few decades ago, but now one is dead and the other is in a nursing home and really cannot make these decisions for me. So now I need to think about picking somebody else, somebody new. And so making sure that you really do have the right people in place to be acting in that capacity as power of attorney for healthcare. What are some of the items associated with power of attorney for finances that will help people understand whether their document is actually up to date or not?
Yeah, great question. I think a lot of the things that I look for in a power of attorney for finances is I really want to make sure that the document has all the necessary powers in it, plus it also has some of your restrictions and instructions in there. Some of the necessary powers that I always look to see in there, I want to make sure we have the ability to create an irrevocable trust if need be. Some of these documents just mention trusts. According to the statute, trust does not include irrevocable trust. It's very specific. I want to make sure we have the ability to give gifts, or we have the ability to transfer assets into said irrevocable trust so that we can do some Medicaid planning and some preparation for that. I want to see that the person has the ability to sign things on the individual's behalf, goes to the post office for them, does their taxes. I want to see a grand list. I want to see pages and pages and pages of all the individual things this person can do. I don't want to see just, oh, reference the statute to this, reference to the statute for that. The statute is not good enough, in my opinion, and from what we've seen, and from me talking to a lot of other financial advisors and bankers and folks in hospitals, the statute is updated once every, few years, maybe? If anybody knows anything about the Wisconsin legislature, it goes at a snail's pace.
Yes.
Maybe they update certain things, maybe they don't. But until those things get updated, it's not like court cases are put on pause. It's not like things that happen in practice are put on pause. Nope, the movie's going on regardless if the script gets updated. And so I want to see that those have all of the updated parameters. Plus, I also want to see some of those restrictions, Kirsten. I want to see that if I grant, for example, my brother my power of attorney, I don't want him to be able to update my accounts so that they're payable on death to his children. He would never do that, of course, but I don't know.
You want to make sure that they don't have that ability.
Right, and I want him to feel safe knowing, well, I know no one's coming after me because here are certain things I can do, here are certain things I can't do. People usually work better when they have those parameters in there. And so also I want to see a guardianship provision, like what you mentioned in the healthcare power of attorney documents. Also, I want to see a whole page that just says, here are the instructions for my agent. Because oftentimes your agent's not going to read through your documents, nor should they. It's about, 18 pages at this point?
Yes.
I don't foresee anybody reading that. That's why I want to see a one-page piece of paper in bold where everything is uppercase and everything's underlined that says, here's what you need to do to make everything a lot simpler and a lot easier for the agent to take over.
No, that's a really good description of all of the things that we're really looking at in a good financial power of attorney and also a good healthcare power of attorney. I think they're just critical documents to make sure that your family is able to move forward, or your loved ones are able to move forward with caring for you in both of those realms. And as hard as it might be, it's so important to get it done in a timely fashion. And so when you have that diagnosis, the best time to start focusing on this is right away, because you don't know what's going to happen over the course of treatment. You don't know if things are going to get better or not, sadly. And so why not just put it in place so that then those documents are workable and usable by the people that care about you, that want to make sure that they have all of the rights and capacities to be able to do what they need to do. You know, I had a meeting a few days ago where this was front and center, the items that you were saying. The individual is now in hospice, looks like he might be in hospice for a long time. The value of the estate is at a level where we definitely want to try to protect these assets for the wife, who is 20 years younger. And they have dragged their feet on this. And so now, looking at the power of attorney for finances that was in place as of 15 years ago, there's no right under that power for her to open up a Medicaid compliant irrevocable trust. And further, there's no power in there that allows for her to transfer any assets into that trust. And so without those two important clauses in the power of attorney for finances, she's now really stuck paying for care at $3,800 per week.
My gosh.
That is going to rip through their approximately $1 million of assets. So it's unfortunate that we're in this situation. And so that's why I think when we were sitting down and talking about what we really want to convey to our listeners, we really want to convey to you how critical it is to not only have power of attorney for healthcare and finance documents in place, but even if you do have them in place and then you get the diagnosis, go back and look at those documents, because they might not have the provisions in them that will allow for your loved ones to do what needs to be done in order to make sure that we're maximizing your financial desires and your financial wishes. And so it's just absolutely critical to pull those documents out and look at them. I can tell you 100% if they came from a hospital, they're not going to have the coverage that we really need in those documents.
And how much will this end up costing this family? To be determined.
We have another client where that's exactly the problem. The problem is that she has now been declared incapacitated. We have to start a guardianship in order to put assets into a Medicaid compliant irrevocable trust. So now we need to ask the court to give us the authority to do that. Hopefully they will, but we're in litigation now, and that's when things get a lot more uncertain. So these are just some anecdotal pieces of information to help you become motivated to come on in, bring your documents with you. We will look them over. We have never ever redone documents that were great. Am I right about that?
Right.
There's no reason to.
No.
But
there was one time that a client brought in a document from about 10 years ago that had all the powers that they needed on there. I said, this is, not only is this fine, I'm going to call the lawyer and I did. I called the lawyer who did the document. I just said, thank you for somehow having the forethought 10 years ago to put this stuff in your documents. I know that all of your clients are good to go. And so, if I see a document that has all the things in that they have, why redo it?
Why redo it? There's no reason.
No.
Well, hopefully this has been helpful for you, and that's because we are here for you today and here tomorrow. Thank you for joining us, and we'll talk with you next time.